welcome to Legalese. My name is Vince Perryman and I'm a local attorney with the law offices of Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show covers divorce odds and ends. With us now is attorney Jason Nowlin of MidSouthAttorneys.com. Jason, thanks for being with us. Today's topic, it's kind of a strange one there where we call it divorce odds and ends, but there's a lot of little nuances with divorces that they're common practice to attorneys, but they're not normal occurrences to people going through divorce and all. And I know we've got several different things we can talk about, from mandatory injunctions to temporary support hearings or temporary custody hearings, and also relocation statutes, things like that. Where would you like to begin?
Well, I think we'll start logically from sort of the beginning of the process, which is the filing of a complaint for divorce. And there are a number of nuances and intricacies involved in the divorce process, and some of the things kind of do fly under the radar, as you've said. One of the things that applies when you file a divorce under Tennessee Code Annotated 36-4106 is there are a number of mandatory injunctions that issue upon the filing of a complaint for divorce. And mandatory injunctions, in essence, prevent you from doing something or direct you to do something. The court, by an order that automatically issues upon the filing, is setting out certain things that you either can or cannot do. Some of those, I'll just run through a list of them from the statute itself. There's automatically an injunction restraining and enjoining both parties from transferring, assigning, borrowing against, concealing, or in any way dissipating or disposing without the consent of the other party in order of the court of any marital property. Nothing herein is intended to preclude either of the parties from seeking broader injunctive relief from the court. So upon the filing of a complaint for divorce, neither party is supposed to sell marital property or dispose of it, give it away. Makes sense. I mean, the court wants to make sure that the marital property is preserved so that it can be divided equitably. Expenditures from current income to maintain the marital standard of living and the usual ordinary cost of operating a business are not restricted by the injunction, however. So, if you're running a small business or some type of business, you can continue to have the normal expenditures you would have to generate income, which obviously is needed for the support of the parties during the pendency of the divorce. There's an injunction restraining and enjoining both parties from voluntarily canceling, modifying, terminating, assigning, or allowing to lapse for non-payment of premiums any insurance policy, including but not limited to life, health, disability, homeowners, renters, and automobile insurance, where such insurance policy provides coverage to either of the parties of the children or that names either of the parties of the children as beneficiaries without the consent of the other party in order of the court. So for logical reasons there, you can't simply go cancel your insurance on your spouse upon the filing of a divorce. The court decides through its final decree some of those issues pertaining to insurance and things of that nature.
And I think in regards to health insurance, there's another caveat in there that's important to note, because Methodist Hospital and Le Bon are the ones that are the most active on collections of debts. And if they can't locate say your wife had surgery, say they can't locate her, well, they will go after the spouse saying that they're liable for that medical debt. And there's case law out there that says that. So with this, if you went and canceled on your spouse and they incurred some medical debt, you're shooting your own self in the foot.
Yeah, you might get stuck with the full amount of the bill and being legally liable for it due to your marriage.
And then the other thing too is say you've got one of those Porsche hatchbacks and you decide you're going to cancel the insurance on that, and your spouse is driving around in it and they flip it and it gets totaled out, and you now don't have a conversion into money from the insurance policy. So that also makes sense there too.
Correct. There's also an injunction restraining both parties from harassing, threatening, assaulting, or abusing the other, and from making disparaging remarks about the other to or in the presence of any children of the parties or either party's employer. Again, sort of a common sense provision, trying to get the parties to play well together during the process. There's an injunction restraining and enjoining both parties from hiding, destroying, or spoiling in whole or in part any evidence electronically stored or on computer hard drives or other memory storage devices. That's one that's often overlooked. I think there's a tendency for people to try to cover their tracks in some situations if they've been doing something wrong, and potentially under this injunction you could get yourself in some hot water from trying to conceal it or destroy the evidence. There's an injunction restraining both parties from relocating any children of the parties outside the state of Tennessee or more than 100 miles from the marital home without the permission of the other party in order of the court, except in the case of a removal based upon a well-founded fear of physical abuse against the fleeing parent or the child. In that case, there has to be a hearing and some other things take place. And as I said, the provisions of all these injunctions that I've just discussed briefly are supposed to be attached to the complaint for divorce to put the other party on notice that these injunctions are in place upon the filing and service of the complaint for divorce.
And when we say service, that's when the process server or sheriff process server walks up to the other party and actually gives them the papers.
Correct. I mean, it could involve someone knocking on your door and serving you papers when you open the door. It could be you could be walking down the city street and they place the papers on your body. Either way, to initiate any legal process correctly, there has to be service of process, meaning the proper service of those papers on the defendant who is being sued.
And then I think this is a good point to also bring out another caveat, which I know sometimes when I'm running through somebody on a new divorce complaint, I fail to ask a very important question, and this is something that the clients can help by asking, telling their attorney if there's anything else they think that their spouse should be enjoined from doing, such as, if somebody was worried about some antique clock that they had left in the home being destroyed, getting the court to add in that specific language too.
Yeah, that's correct. I think the initial provision, I believe, within the injunctions I read said that, nothing about that is intended to be an all-inclusive list of what relief you can get from the court in terms of an injunction. Each case is different, and if you have facts that give rise to a claim for relief, if you have a factual scenario that you can present to the court of some sort of imminent fear or danger of something occurring, then more than likely you're going to be able to get injunctive relief if the court agrees with you that that's something that the court should be concerned about, obviously. But.
And it's one of those that the court and your attorneys aren't going to know unless you tell them, because they're not mind readers.
That's correct.
And what is obvious to you because you've been in that relationship is not obvious to outsiders coming in. So, and we'll get more into this when we come back. When we return, we'll continue our discussion on divorce odds and ends.